Good morning. I'm Steven Levitsky, the director of Latin American Studies, Rockefeller Center DRCLAS. Welcome to the 11th seminar of the Academic Forum for the New Constitution Chile. How does the proposal of Chile's new constitution look? This forum was organized by DRCLAS, especially by the regional office in Chile and the Andes and Southern Cone program. Before we could begin, we would like to thank you to the four panelists and to thank and acknowledge Marcela Renteria, the executive director of the regional office of DRCLAS in Chile, the main strength in all sense behind this forum. I would like to thank the DRCLAS team, Jimena Condina in Cambridge, Dana Barra in Santiago. For almost 2 years, DRCLAS has been offering a platform for an open debate and a high caliber debate on critical subjects that the Chileans are thinking of to start. It's always the idea to look for the academia members that are international and Chilean on the political realm with different points of view and different political perspective. We have a consulting committee with 7 professors who work in the institutions in Chile: Claudia Fuentes, Claudia Hayes, Juan Pablo Luna, Cristian Rodriguez, Sol Serrano, Sebastián Soto, and Verónica Figueroa. Verónica is absent because of her participation in the government. As you know, the constitutional process in Chile has been paid attention not only in Chile, but several parts of the world, which includes the United States. The Chilean process has been very innovative in several ways, but as you know, destination continues to be really open, right? A couple of logistical factors. The event is been recorded. We also have English and Spanish simultaneous interpretation. If you want to listen to the presentations in your language, just go to interpretation on the lower side of your Zoom screen. Third, if you have questions and we want to have questions, so please send it through Q&A in the lower side of your Zoom screen. After the 4 presentations, we will have a session for Q&A, but you can send your questions at any time you feel comfortable with. These forum events are co-hosted by Luksic Scholars Foundation. We have also the support of the Public Affairs Institute of the Universidad de Chile, Milenio, Fundamento de los Datos Institute, the Constitutional Laboratory of Universidad Diego Portales, the Law Department of the Catholic University of Chile, the Political Sciences Institute and the Department of Political Science in Universidad Católica Chile, and also Harvard Chilean Students Association. So far, during the first 10 debates of this forum, the approach has been more speculations rather than anything else, as we didn't have a draft. We also have the political situation that is really poor. The elite has been questioned opposing the draft. Ricardo Lagos, former president, just declared that the new constitution has not really consensus. Former President Frey just said that he will vote against, and according to the polls, this draft could be rejected in September. If that happens, Chilean people would have to start again the process or to move to a constitution that was rejected by almost 80% of the voters. So this is really, I don't know how to say, confusing. I know very little cases. In fact, none. No case in democracy where the draft that comes out of a constitutional assembly is rejected by the society. But that is telling us something about the representation crisis that we see now in Chile. The idea today is to focus on the content of the new draft, the strengths, the weaknesses, and what are really the aspects that are new, innovating, what are the most important limitations. We have really been lucky to have amongst us two international experts, Roberto Gargarella and David Landau, and two Chilean experts, Miriam Henríquez and Alejandra Ovalle. Each of them will talk of about 10 to 12 minutes, and if we have the time, we will have some Q&A session. And then I would like to introduce the four of them just as they will be presenting. First, Roberto Gargarella is a professor of constitutional theory and political philosophy at the Universidad Torcuato de Tella and professor of constitutional law at the Universidad de Buenos Aires, who has been one of the most important and influential constitutional law professor, publishing 7 books on constitutional law and political philosophy, like in 2010, and Cambridge University Press published The Legal Foundations of Society about a decade ago approximately, and The Law as Conversational of Equals, a very important book that was just launched in April, and I would recommend you to read. Roberto has been professor and researcher visiting in Harvard, Columbia University, in NYU, Bergen, and Oslo in Norway. One of the most intelligent professors I have ever been lucky to meet. Then we have David Landau, the Dean of the International Programs and Mason Ladd Professor of Law in Florida State University. David, among other things, used to be my thesis undergraduate student 20 years ago. But despite of that, David has turned into one of the better experts in constitutional law when we have compared law in publishing different books about abusive constitutionalism, populist constitutions, writing of new constitutions, and democracy coming. Author of Conspiracy Constitution Maker with Hammer Lerner and Abusive Constitutional Borrowing with Rosen Exon. Currently, David is in Chile. Yes, yes, with a Fulbright scholarship to follow the constitutional process. Third, we have Miriam Henríquez, the Dean of the Faculty of Law and Professor of Political and Constitutional Theory and Constitutional Law at Universidad Alberto Hurtado, who is also the author or coordinator of 3 books of constitutional law and human rights as the sources of the order of the Constitution in Chile that was published in 2016. I have to say constitutional once again. I could really faint here. Dr. Henríquez is a PhD in law in Santiago de Compostela University and master's in Universidad Católica de Chile. She's also the coordinator in the Capital Formation Program of the National Commission of Science and Technology. And since the 2020, she's been a member of the new Gender Advisory Council for the National System of Science, Technology, Knowledge, and Innovation. Miriam, thank you for being with us. We also have Alejandra Ovalle, Associate Professor of the Department of Public Law at Pontificia Universidad Católica de Chile, where she teaches public law and constitutional law. She's also the director of the Constitutional Forum at Pontificia Universidad Católica de Chile, a specialist in constitutional law. She has published several articles on constitutional issues, including economic constitution and the role of Congress and the Congress members. Thank you very much to the 4 of you. I will put myself up and let's start with Roberto, please. Thank you, Stephen. Just let me know when it's close to my 10 minutes, please. Okay, it's a real pleasure and honor. It's my admiration to have this team as a panel, and I really appreciate the opportunity. The Chilean process has been something that I have been interested, just like many of you, looking from outside. I could advance a very favorable opinion despite of the critique. I would like to have some brief considerations on procedures and some on the substance of the Constitution itself. About the procedure, I think that especially subjects like these, we have several things that we could say about Chile, but many learnings about creating the constitutions in the world, in the Western world. The first is about procedures. I think that the way in which this has been faced is part of the richness and also part of the problem. The model has to do with what once Leon Elster presented as a model of the glass hour, strong in the citizens' intervention, then a writing that was more close, and then popular ratification at the end. I think it's a great problem to have that model. My vision would put the center in the conversation, and the writing process should have been, I think, more open to the civil society because of different reasons, to protect of influence that is unduly, to gain more. I don't know, they tried to write it in that way because the representation of the civil society started working very isolated from society, with not too many bridges of the civil society, not because of rejection, but because they didn't build the bridges when they were able to. And that affected legitimacy in part, I think, and explains partly the distance that some citizens, if not many citizens, feel with what happened inside of the convention, as if the people working there was an elite, a process that was marked by an anti-elite movement, and then they realized there's an elite working, or a group that became elite as they're not working in contact with the civil society, something that they could have been doing. So I think I could say they didn't learn from recent experiences like Irish, and they really were building bonds. One thing on the closure option is an absurd, not for Chile, but it has to do with an idea that is really wrong for me in terms of what democratic participation means. This has to do with the citizen making decisions and having some control inside of the convention itself. But then when you have a binary option at the end, yes or no, if that becomes interesting for the citizens instead, it's a problem. Any decent citizen with half of the information reasonably could say, I agree with this, I disagree with that. I would like this, I would like to modify this. I would read the 5th article, I will expand the 6th, I will reduce. I guess I have to say yes or no on a full package. So many people, because of their rejection strongly, one article will eventually reject the whole constitution, even if they are in agreement with the 80% left. So that is a real awful option. And it's a very problematic way on how to understand citizens' intervention in the constitutional creation process. It's not the Chilean process. It has been extended in Latin America, and it has to do with the poor contribution of many of us constitutional law professors who were not able to clarify something in regards to it. Democracy feels offended in a way of proceeding like that. That said, which is a critique about basic aspects of the procedure, I would say, despite of the critique, no one has doubted that what has been done has a democratic legitimacy level that is extraordinary compared to what was before. And the fact is coming out of a constitutional word marked by Jaime Guzman, and the idea that was explicit by Guzman to turn the field so the opposition, the enemy, is not able to create the reforms they want. Bringing it out of that word is so important, as the democratic legitimacy that is obvious in this process, despite of the failure, should be enough as a reason to put the other things aside. But however, that doesn't seem to be an important fact to have the weight it should have. Now I will go to the substantial issues. I think, again, this constitution improves what was there, and even what is established, even with the problems, will have problems that will be solved with democracy a long time. So fear, if they jump into the void, a very problematic idea used by the enemies of the Constitution, I said that between inverted commas, that appears if it is not approved. It is a decent constitution, interesting constitution, placing Chile in the train of the modern constitutionalism, including, especially with the good and the bad, the Latin American constitutionalism. A very little footnote. Nothing of what has been bad happening in the Latin American development has to do with the nature of this constitution. Constitution, it is important that we understand this, will not change the life of anyone. It will help or it will block the solution of some problems. This constitution helps to solve some problems and could have been doing many more things that they did not. But in the substantial issues, it is running with a great advantage compared to the previous model. And that is that it puts aside some of the problems that used to be parts of the old constitutional, were including the prevention of constitutional control to prevent basic social reforms. That in itself, I think it's the reason to support the Constitution. But saying it improves what it was there, eliminating some things that are not good, brings some problems. Again, two-phase problems. The emphasis in Latin America for more than 100 years has been the emphasis on the robust list of rights. And I think it has to do again with a poor reading of constitutionalism. But under the framework of the constitutional context, where you have a constitution that was unduly done and really poor to the extreme of the problem, it's good that this constitution adds so many of the rights they add, as it used to be very Spartan. So it includes something in the important things, in the very few things that a constitution could do, not having rights. Let's say social rights, cultural rights, economic rights in an explicit manner, just as not having the indigenous people recognition was part of the problem as it blocked some initiatives. I was listening to a former minister of Bachelet making clear this point. Myself, as a minister, when it was not good days, I initiated reforms that were blocked because the Constitution was not allowing it. It was not including in the Constitution. So bring excuses to political people and the judges that are hyper formal in Latin America, especially in the most formal countries like Chile in Latin America, the excuse of saying the right to education, housing, and health is not in the Constitution, I can't do a thing. Then if I can do something is unblock it. So bring that block out, or blocking out is important. Part of the Constitution is good that they included these new rights, and it's part of the most interesting thing that the Constitution is doing, just as recognizing indigenous people, that while not having the constitutional status was part of the problem. So when we said that, I think that should have been complemented in all the constitutions of Latin America with a reform that is part of the constitutional reform that was not done, and is part of the traditional problem that I always called the machine room problem. This is a radical reform that is demanding, substantial, important in the rights, not supplementing that, not adding that or going together with that type of reforms with modifications that are in agreement with the organization of power. That was not done, as in general, it was not done by the Latin American constitutionalism, which is part of the problem. Why? Because it could put in some risk the implementation of rights. But please, the most critical, the critique of constitution is because they go too far. My criticism is they are too close, not too far. They could have done many things with a life that is effective of these important rights that should have been included, and it was. So I would criticize for less, not too much. Well, some things have been done that are relevant in terms of parity organization. I think that trying to have a differentiation of the bicameral thing, the chambers, I think it is less than what they could have been doing or could have done. In terms of justice, maybe a council of justice is better if we don't have it. But again, it is too little, I think, too little with the type of rights and too little in regards to the effective possibilities they had. It attracts my attention that one constitutional members that are fed by social movements would have not made a higher effort to have a power organization reflecting and helping or putting themselves into service of these social movements. That is a democratic representation that is different from the traditional. Again, in that sense, what has been done improves substantially what's there. It eliminates blockings, adding rights and recognitions that should be there. But the sour taste is it should have been done with more, and it could have been done with more in terms of organizational power that is accompanying and servicing the list of rights, and the organizational power that is more interesting in regards to the social base that was fitting at. So today what we have added is institutions of the old institutions of Latin America that are Western, as we can find them in the United States or in the old European constitutions or old Latin American constitutions. The Constitutional Court, very similar to what we found, checks and balances systems. Many people said, no, we have a problem here because the controls were unbalanced. No, nothing to do with that. I think that it has a poor understanding of the checks and balances system. What we want from checks and balances is another thing. Checks needs to come from the citizens. So I feel pity because there's less there than what could have been done. But you reduce the powers of the old Senate, the Constitution is unbalanced, not at all. That is the old traditional scheme, very similar to what you had before. And in that sense, the old presidentialism, old organization of power, old organization of justice in the parliament that helps the traditional representation form is not really attractive because it is too much of similarities to what we had. I just have 2 minutes, or is the time 1 minute? Okay. So last note on rights. Rights are not planets that are out there and we acknowledge them. Rights are the historical recognition that we do when we look back ashamed of the mistakes we made in the past. So we take some commitment. That means we said we will write them as rights. We will make an effort to take care of this or to assure this for the future. So the critique that the Constitution could receive is in rights is absurd, and it has to do with the notion of rights that is kind of poor. So my general balance is above what was there. It eliminates logs, includes commitments that should be there, and many of the adjustments that we need to do are possible, especially in the future. I would have loved, and I think it would have been possible to make a constitution that is a lot more interesting, but what we have is a lot better than what we had. In terms of democratic legitimacy, you can't compare to the former constitution that didn't have it. So there are many reasons to support it with the certainty that what is missing, it's possible to be completed in the years to come. So I'll stay here. Thank you if I exceeded my time.
We will go now to David Landau. Thank you. It's a great honor to be here. And with my Professor Steve, I will speak English because it's easier for me.
Reflects what I would call the dominant tendencies of neo-constitutionalism in Latin America. It's kind of the full flourishing, I think, of regional tendencies in constitutionalism for good and bad, I think, for some of the reasons Roberto just laid out. So it picks up tendencies from a lot of constitutions in the region, Bolivia, Ecuador, also places like Colombia, Brazil. And you see that particularly with respect to the rights provisions, the rights of the pueblos originarios, environmental rights, social rights, a high quantity of autonomous institutions, all of those sorts of things. That said, I think there are some genuine and very important innovations in the text. The most notable aspect for me is parity, right? The gender parity provisions, which I think will be a model for other countries, both regionally and globally. I think there's little question that will be influential. I agree with what Roberto said, here and elsewhere, to the effect that the Constitution often seems to prioritize rights over structure. The key debates at the convention were about rights. Many of them, there was a real emphasis on rights. But I think a little more than him, I would be inclined to say that I wouldn't downplay the extent of the changes in the structure. They're significant in some key respects. I think that's true, for example, of decentralization, that's a major change in the nature of the Chilean state. If you think historically, how it's going to work out is very complex, right? But there is some major changes to the structure of government. And then I think importantly, there is increased flexibility in some respects in the new constitutional order. The elimination of most special quotas for laws, the easier amendment rule. In other words, it's a more flexible constitution in some ways. And I think parity, as I mentioned, plus the reserved seats for the pueblos originarios in the legislature will make important structural changes to the way the legislature works and functions. So there are some aspects, I think, of structural change along with the rights provisions. I think the new text has the potential to make important and positive changes to Chilean society. I think the provisions in the text, generally speaking, are reasonable and kind of within regional tendencies. Having said that, I want to use much of my time to make three observations about tensions in the process in the text that I think are worth drawing out and that do worry me, right, in different ways. The first is, I suppose it's an abuse a little bit of the format because it's less on the text and more about the process. But as I will say, I think they're linked, right? And this is the tension between the design of the process and its political results. I think one way in which the Chilean process is a model, and I admire it very much, is in its use of law to constrain and shape constitution making. It's a deeply legalistic process. That's not an unmitigated good, but there is some good, I think, that comes out of that. Different from the use of constituent power in many other recent cases in Latin America, which were not constrained in the same way. The political agreement and the technical commission, in my view, did a very competent job, a very good job in constructing a set of rules, the key piece of which was a 2/3 rule for approval of the text. And the expectation that came out of that was that the major political forces would have the power to shape the text, and that included the right, essentially, the center right and the right. The elections, of course, that didn't happen, right? The combination of electoral rules in the moment, the right fared quite poorly in the elections. And so the expectation, in a sense, that I think the center right had of a constitution drafted between the center right and the institutionalized center and center left was not met, right? And you can see in the, there's a project that the Centro for Estudios Públicos is doing that has like nominate scores within the convention. And it's very interesting to see where the 2/3 falls within the convention. And it's way to the left of the similar point in Congress. It excludes the right. It even excludes centrist elements of the prior concertación, right? Groups close, for example, to Christian democracy. it's kind of like around the Socialist Party, somewhere around there. And so that means that what happened, right, in the convention is that the institutionalized left, key groups like the Frente Amplio and particularly the socialists, negotiated with the independent left, right, sort of non-party actors on the left, to negotiate most of the provisions in the Constitution. I thought it was interesting in the closing remarks, one of the center-right delegates, this was Christian Monkeberg, called the decision by the center-left parties not to negotiate with the right a historic error. But I think in a way, it was more of an imperative given the composition of the convention, right? That there's just the way to get the votes for the institutionalized center-left parties was to negotiate with the independent left. The votes just weren't really there on the right to allow the negotiation to occur. The question that I would raise is, should we worry about this? I think it's an interesting question. I tend to think yes, not so much in the text, which, as I just mentioned, I think is very reasonable and makes important advances. But I often think that in constitution-making moments, the moment itself, the political context, can be as important or more important than the text. And here, the result of the moment, perhaps inevitably, has been continuing polarization, in some ways feeding increased polarization within Chilean society. The campaign, of course, is going to be ugly. I think already you can see that. Will the Constitution be rejected, which would be, I agree with Roberto, I think disastrous for Chile? I expect not. There's some comparative data on this that suggests, by Zach Elkins and Alex Hudson, that shows that these kind of referendums are approved, I think 94% of the time, as the statistic. But it's worrisome, I think, in this case, right? It certainly seems possible. And if it is approved, which I expect, it won't be approved by a ton. I worry about the long-run effects of that kind of a context, right? Of constitution making on the product. I don't think it's something that can't be overcome or wouldn't be overcome, but it's certainly worrisome, I think, in some ways. The second tension I want to raise briefly is the tension between more or less democracy at the convention. And I think this is interesting. There were some key actors involved in pushing for a new constitution and making it, who saw the key problem with the constitution is not enough democracy, too counter-majoritarian. This obviously is the traditional critique, right? One of the traditional critiques in the 1980 Constitution. And some of these problems were removed over time, others stayed in place. The new Constitution responded to some of the remaining problems with things like the difficulty of amendment, the special quotas, et cetera. And so in some ways, it's a more democratic constitution, a more flexible constitution, one that creates space for representative democracy. In other ways, though, I think at the convention, there was a lot of distrust of at least representative forms of democracy. And it makes sense, given that there was a big block of independent left actors that don't have much experience in representative politics, came from outside the parties, and saw this as a moment at which they had the ability to shape institutions. They thought that, I think probably correctly, that they would not necessarily be in this position again. So their response was a different one. Some very detailed constitutional provisions, in other words, a lot of constitutional specificity with regards to the rights provision, and the creation of a lot of autonomous bodies outside of representative government, more than I've ever seen in another constitutional project. Not just traditional topics like elections, but also things like water and the environment. There's really a lot of these independent institutions. So there's workability questions there, but I also think it's interesting what that says about the relationship with democracy. Similar tensions I would just mention with respect to the judiciary. For both Chile-specific and more global reasons, very little trust on the left at the convention in the judiciary. So the result is quite interesting, creation of a lot of rights without a particularly powerful set of courts, I think, to enforce them. The new constitutional court, for example, is weaker than the old one. Final point I want to raise briefly, tension between the constitutional text and its implementation. The new text makes a lot of key changes. It's a very progressive document, a very admirable document in my view. What's interesting is figuring out how the new text is going to be implemented. Many of the new constitutional provisions have these by law provisions, por ley, right? Provisions in them. The legislature then is effectively going to be charged with implementation. The transitory or transitional norms have not gotten that much attention. I think they should, because they are here as elsewhere very important in mapping out how the new order will come into being. And compared to the ordinary text, they're quite conservative in my view. Most of the institutions only come into effect very gradually. The new Congress, for example, in 4 years. The exception is the Constitutional Court, which is going to be turned over, which will be turned over quickly. The norms also create very few special procedures for passing implementing laws. They effectively rely on ordinary congressional procedure. This is different than other experiences. I know about, particularly like Colombia in 1991. They do create timeframes for passing some laws, but generally without any consequence if the time frame is missed. So I think there's a pessimistic and an optimistic way to view this, and this is where I'll conclude. The pessimistic way, of course, is that the implementation will be frustrated. Congress will end up being fairly hostile to the project and will also be overwhelmed with the need to pass new laws, including ones creating and defining new state institutions. Implementation then of issues close to the heart of the protests and the spark to the process, like social rights, will not occur, will occur slowly. The Chilean courts will not take much of a lead in implementing the text either, as I've already suggested. So there is a significant risk, I think, of, rather than the risk the right sometimes sees of the process going totally off the rails and massive changes in society, I think there's a real risk the text will be approved and then not much will happen, right? I think that's a significant risk. The optimistic route I'm hopeful for, but not sure about, is that the gradual implementation relying on normal politics will play a positive role. The convention reflected key aspects of Chilean society stem from the social protests, but also clearly undervalued some important sectors in Chilean society. I think a key thing to understand is that the constitution making process is not done when the text is done or when it's approved. It's a long process. And the political movements like the right with too little voice in the convention are going to have it in the years ahead during the implementation process. They'll have a lot of power should they wish to use it to shape what the Chilean constitution actually means, how it operates. I would hope, on the optimistic part of me would hope, that this over time would help to build a constitution that reflects a balance of forces and reflects Chilean society well.
Thanks, David. Ahora, Miriam Henríquez.
Miriam Henríquez. Thank you so much. Good morning, everyone.
I would like to thank you for the invitation to participate in the forum, and it's an honor for me to share this panel with such distinguished professors. The question that is asking us is, what are the strengths and the weaknesses of this new framework, I would say, for a constitution that is represented exactly in the project that we are knowing of, a new constitution? We stop talking about the draft and we talk about the constitutional text itself. And in my presentation in these 10 minutes, I will be aware of we have been asked for strengths and weaknesses. I will try to focus on strengths. There are weaknesses that could be overcome and improved and perfectioned. I will focus on 4 points or aspects, questions that were in doubt, if they were fulfilled, doubts, if the election promises of the ones elected were fulfilled in the text, if they were fulfilled at a level of declaration, or they were reflecting rights that were impacted in the organization of power. And eventually, if I have the time, if there was a constitutional transition. Let's go with the first thing. If these concerns that were part of the process were anticipating during the work of the convention, they were talking about timeline, the deadlines, quorum, fulfillment procedures and how complete the text could be. Constitutional Convention, with some adjustment to the schedule in several situations, they adjusted the schedule. They fulfilled a text that was delivered that was part of doubts in February and March, and even some said that the Constitution would need a reform to extend the timeline for the Constitutional Convention. It was not necessary. 9 months plus 3 more. The Constitutional Convention was able to deliver a text that will be part of the plebiscite. Then they approved all the constitutional norms in 2/3. That is also something that was part of the debate, risking the legitimacy of the agreement of the two texts. Constitutional Convention was able to issue 4 rules to rule the way they will function, and it was not complaints against the Supreme Court. That was the procedure that was considered to solve lack of compliance of process that was part in the Constitution and the Convention itself. And the constitutional text that we are analyzing is a text that includes all the parts that a constitution should have or regularly has, like the preamble, principles, the rights, the organic part, the reforms. It was also part of the concerns if it will be a complete text, which is orderly, placed in harmony. In a very brief time, the members recognized that the process was difficult because of the time assigned. The text is the first that has been prepared in democracy in Chile by the diverse, parity, and represented already reserved seats that we think are of value. Second question is, if the proposal for elections of the ones that were elected when they were observed by new observatory of Constitution of 3,500 propositions and the priorities that eventually could be established in regard to the people who were elected for this constitutional convention. And they were talking about constitutionalization of values like dignity, equality, social protection, and state presence. Also social rights to be guaranteed, basically, and in that order: health, education, social security, housing, water. New rights that are gender, diversity, environment, girls, boys, teenagers, science, culture, technology. The third order of the changes in the political regime, incorporating popular participation, decentralization to be effective, and also gender demands and recognition of First Nations. That is the ranking of the propositions of the constitutional elected members. All these themes, all the ones that I've mentioned, were established in the constitutional text proposed to the plebiscite of September the 4th. I would like to highlight that these demands, as they were elected, are part of the constitutional text, and they are the main, really main and core pillars of the social political pact that they propose. First, the social democratic state of law puts away the lack of or false dichotomy on the political and social rights on one side, acknowledging the existence of the First Nations, original peoples, inviting to be recognized as plurinational and intercultural state, distributing the power between men and women in balance, establishing a parity democracy, putting a non-divided relation between human beings and nature, and they claim an ecological state, getting the decentralization demand, establishing a regional state. The way it is stated, these respond to the propositions that were shown. Particularly, I would like to highlight this, that it exceeds the mere declaration. And as a system, it declares the principles, it gathers the rights, but also establishes part of the organization of power and the new distribution of power. Then I would like to reflect in a way the recognition of these pillars or pacts and the realm of it, which is not just a simple declaration or statement, but they are acknowledged in the rights and the organization of power. Because of time, I would simply say, just mentioning examples. Gender demand. Think about it. The proposition of the constitutional process has also the origin in feminism, demands, the historical ones. The parity convention is a particular core thing of the constitutional, maybe it's the only constitution that will be generated by the parity membership. And it was concerned and object of some doubt if a parity convention would gather the gender demands, being able to contain them as norms. 8% of the norms of these constitutional texts gathered gender demands. Doing it as principles. They initially established in the constitutional text the party democracy. They establish a principle of substantial equality of gender that is supplementing the formal equality, acknowledging some rights or a differentiation for women, which is not that there are many rights that are particularly in regard to women, but are maternity and rights with prohibition of gender violence and the right to live a life that is free of violence, acknowledging as a right that mainly women, girls, and female teenagers should have. And they are established as the focus of gender, like health, education, social security, sexual and reproduction, and the right to take care. And eventually, I would like to reflect that this is like a system, the principles, the rights, and the organization of power. It is not just acknowledging rights and principles, but this set of demands is reflected in the parity. That means that the members of the state that are part of, I think I'm close to the 10 minutes, but it has to do with the social and democratic state of law. That replaces the subsidiary state that is implicit in the current constitution and implies a series of changes that at least face a new role of the state, of the individuals, and establishing social rights that are guaranteed, where mainly the state is the one that holds the rights. National systems of health, education, social security, and care. The social rights will be under the umbrella without distinction, all the rights without distinction, with fundamental rights cautions, and they create the defense. I could add some political things, but I wouldn't have the time. And the fourth was that even the constitutional text proposition gets to the point of transition norms. So if we take the work of the Constitutional Convention, it was a possibility that they could have not added transition norms. They proposed some constitutional transition to tell the norms to be adapted and the timeline to develop the content of the Constitution and what will happen with the norms that are current that are not compatible with the possible future constitutional norms. In regards to that last point, and I will be finishing now, the temporary norms or transitory norms, they not foresee to be applying the new norms and not the old norms. Among them, a very complex situation that has been complex even to the previous reforms to the current constitution. They establish legal abolishing or derogation unless they declare the constitutionality, the ability of the state organizations to write the new Carta, and derogation of law that could be abolished through a national referendum. In my presentation, I wanted to highlight the aspects that are favorable or positive in this constitutional text, and I insist and I acknowledge there are weaknesses that could be improved, that we could continue talking. So thank you very much for this invitation.
Thank you, Doctor. And we have Alejandra Ovalle. Thank you, Stephen. Good morning, everyone. It is a great pleasure to be part of this group of speakers. I have to introduce a counterpoint in this conversation, and for that, to do an evaluation, well, what we need to do is to distinguish among two levels. First, the objectives or purpose that underlie the proposal of new constitution. And then we need to leave aside the specific formula proposed by the constitutional text in terms of reaching the objectives. Regarding the objectives, I need to say that the convention did a good job in identifying a line and picking up many issues that were present in the deep crisis in October 2019 that gave origin to the process. Miriam also added that incorporated in the promises and the proposals and of the campaign of the conventional, and that show a social dimension, and that take fills the gap between the issues and the constitution. And beyond that, beyond identifying the objectives, that the 5 objectives that Miriam pointed out, that is shows that it's clear and evident that these are issues that affect the whole constitutional process. And there is a broad debate in constitution still being generated. It included many criticism, polarization, and in spite of that debate, academy, politics, and society in general, they were moving towards these objectives. So in spite of discrepancies in specific standards and what has generated dialogue, a social dialogue, has helped to bring together, moving forward in consensus in constitutional areas that were not fully extended or fully broad at the beginning of the process. So I think that pointing this out between objectives and constitutional formulas is relevant, because whatever the result of the referendum, constitutional discussion will continue. It's in different contexts, in one or other scenarios, but this discussion will continue. Therefore, it's not an anecdote that it has been what has been generating a certain consensus, a broad consensus regarding the access or alignment that should be present in the new Constitution of Chile. This distinction is important. It is important because in the public debate, there is a confusion or a mix of both levels, which is objectives and the formula or the constitutional arrangements. It's totally different to see, well, it's moving forward in decentralization, in social protection and gender equity. Yes, it is. It's moving forward towards that. And it's calling for adhesion in different areas. And what is crucial in the next referendum is to analyze how they do that and what is the specific, concrete way the constitutional text is tackling these issues and touching these objectives. And today, it shows a different consensus level that is broader compared to what we had at the beginning of the process. And I have a critical vision on this. I have a critical vision on this. And from all the alternatives, the possible alternatives, convention opted in general opted for formulas and definitions that are quite intensive. Others go way beyond, and others are ideologically committed, and others suppose a risk to stability. And as the reference Stephen made at the beginning on is touching that, the lack of consensus beyond evident objectives and guidelines, there are many issues that are seen in the formulas that are specific and concrete. And I don't want just to say these words without a base. I need to refer to specific issues and show where the text is taking these purposes and why do I think it is a mistake. In social rights, the implementation of social rights and not a subsidiary right, and that ensuring social rights and strengthen the role of the state. This was misunderstood. It was understood that the consecration of the social state was contrary to the promotion of civil society and public collaboration, public and private collaboration. The proposal does not prohibit association between the public and private sector, but it's not promoted or funded. It's tolerated, seems to be tolerated. And an example of that is the right to education, the right to freedom of teaching. And in Chile, we have a sector, an education sector, private with public funding, and that is at a school level, university, and that draft creates a national educational system that does not exclude private entities or the privates to participate. So state education is the access of the system. It is a primordial duty, strengthen education, promote the system, and it generates a number of elements that at the beginning, and depending on how it is interpreted, put in risk autonomy and sustainability of educational projects. In private education, it defines education, a common regime, etc. I think that this purpose of eliminating the logic of rights was taken to the extreme of relegating the social function of society, and that has been traditional. I need to move faster. Second objective is gender equity, and that is moved forward in mechanism of a parity rule that does not allow exceptions. And that gives it such a rigidness that accepts fairness and periodic evaluation of all the actions. Recognize and value the indigenous people is important, is a debt, and that is present since the return to democracy. Is expressed in plurinationality, a plurinationality that is then taken forward and moves forward. It moves forward as not, as Miriam is saying, it gives content to the concept. And plurinationality includes the right to self-determination and the recognition of the institutions, authorities at a territorial level, the distribution of power for the governments and administration, pluralism, systems of justice, rights to the land, territory, establishment of restitution as a preference mechanism, the right of water, requirement, consent, and many more. And the point at the time of the proposal is not recognition of the indigenous people. It's not that they're advancing towards autonomy. I think that it might only stay in the declaration, but the way, the intensity, it is regulated. And if plurinationality or recognition of the different nations are seen in the framework of the unity of the state, the text does not give any substantial limits safeguarding this, and that would maintain this in the future and end up in an agreement of a living agreement. And there are others that enter into this. There is an ecocentric vision as a subject of right. This is unique, but it's an issue that is relevant in the propologic vision, because rights are not linked to the human dignity, but it goes beyond that. And it implies juridical effects, and it is a new reading and a new interpretation. And that the context will shed light on the possible effects. Priority in the use of water. The current legislation says that it's priority for the human use. And the proposal is saying that it's not priority, the human use. It is, but it needs the balance on the ecosystem. Decentralization, the substitutes the unit state, and it's deep and it's important. And the challenge is in its implementation. It's an implementation. Political regime, I'm not going to say anything about that. I'm just going to say that in this case, the pattern breaks. We don't have adequate objectives formulated coherently, and that include excessive formula, but we see here that is something partial and a result of successive negotiation and renegotiation. So there is no clear guideline there, and you can identify certain objectives, however, is not absolutely clear. And we can talk about that in the Q&A session. Thank you. We have 25 minutes for Q&A.
So I'll try to make 2 rounds to give you 2 or 3 questions that you can take. Let's say 3 minutes, in not more than that, until we are able to arrive to another one, and we would continue in that same order as before. 2 questions to begin with. First, we have different questions, some about the regime, the defense of democracy in this proposal after the draft. So one, it says, if there are mechanisms or aspects of militant democracy, what are the mechanisms to defend democracy, like forbidding movements or parties that are anti-democratic? Is this new constitution including some self-defense mechanisms? That's one of the questions. Another question from a different political perspective is there any potential elements that could be authoritarian in this constitution? So they make the comparison to the Venezuela constitution of 1999, asking if there is authoritarian elements. Second question that could go for every one of you, some of you touched upon that and others didn't. How can we explain the rejection that we see not on the elite only, but according to the polls of this society? David and Roberto touched upon that subject matter a little bit. emphasizing not just the content of the Constitution, but the political process. Roberto spoke about lack of dialogue that was present, and David talked about the lack of consensus on the assembly and the right sector. But there are several questions about if there's elements in this proposal that could have been fostering rejection that we see in the surveys and polls, like the ambition of the Constitution, so many rights existence, what the economists, without a surprise, call left wing, fiscally irresponsible left wing list, if that is generating or not rejection. If each of you could at least comment a little bit about the sources of this questioning that seems to be that the society is having. If you can take a couple of these questions on this series of questions, Roberto, please. 2 or 3 minutes, part about that, part about other things. The wrong nature of the plebiscite is forcing you to think binary. The consensus has been generated. So now you feel obliged to say yes or no for a full package. Maybe because you reject something, then you said, because of one little thing, the whole package is null. I think it's a very big mistake to place the Constitution on a yes and no binary question for the full package that generates the problem. So it has been placed in a wrong location. About what Alejandra said, there's a mistake in how the rights are built. The rights are not something that are outside, and they're just dignity for human link. Rights are social recognition of things that we think very important, interests that we want super protect. If it is nature, then I could say the right to nature, but it has nothing to do with the essential nature or the judicial nature of rights. The interest that we recognize as very important in light of our history and what we have done. Roberto, we are sorry, but we really hear you really bad. One last thing about the rights and funding, not having some rights, like American Constitution, no welfare rights, which is a big problem, not having welfare rights in the constitutions, in the possibility of having a social reform. So it is very important to include them. So that's the first thing. An enormous good step to include the rights, differentiating from constitutions like the Constitution of the United States or the old Chilean Constitution. Will that put the funds out of the state? Not, totally not. The big risk is that nothing happens, as in many constitutions in Latin America, that they have so many rights and are not implemented, but not that the state gets out of funds. We learned by decades that there are many possible ways between the different branches of power to push for the reform to implement rights, like judiciary power or judiciary branch will call the legislature or legislation branch to, in a dialogue, implement rights that would not risk a thing. The worst risk is that the rights are not implemented in full. That many things happen in the Latin American countries. The worst situation is not to include. The good news is that there are paradoxical paths applied all over the world on how you collaboratively could do within the civil society and the different branches of government implement rights. I could have said more things, but I will skip my time, so I will reserve for the next round. David? very interesting questions. About the first question, if in a sense there is an anti-democratic risk in this new constitution, and if it is similar in the context as Venezuela or Ecuador, I think that is a very interesting thing that we really listen very much in Chile. But to my knowledge, that is an error. And it has no sense to think that something similar to that could happen in Chile. That could be that it is true that in some sense, the texts have things that look similar, like the right to the environment, First Nations rights, things like that. But the problems with the text in Venezuela, Ecuador, Bolivia, it was not the text itself, but the context of the constituent process in the countries where there were a power concentration that was concentrated impressively in strong people, the presidents of the three countries. Like in Ecuador, there are environmental rights that are very ambitious and interesting. But in some sense, which show we wrote about it, that it was like a trap, that the rights were there, but there was not willingness taken seriously on President Correa to implement it. So I think that the political context in Chile is not, I think we do not have that risk in Chile. That something interesting could happen in Venezuela, or something like in Venezuela or other countries, that has no sense to me. And the second point about the problems with the text itself, I wouldn't say it's perfect by no means, but I think it's a very reasonable document, though. There are some elements that are problematic. Like if we look at one element that could cause some tension, previous consultation, which is very important in compared constitutional law and international law. The consultation to First Nations that is existent in the human rights, that's a type of right. I was a little bit concerned that in the text of the Chilean constitution is stronger than that, says consentment. So if we look at the compared experience, that type of concept could create some stress. Consent could create a stress at the same time. The text itself, I don't think will make too much. Some subjects in structural changes, it will happen. But the rights, which are things where people are concerned, they will require a very long process, as I said, to be implemented, of laws and things like that. And the people in charge will be very different to the people in the Constitutional Convention. I think it will be okay, as there are some things to be concerning. They will be interpreted and implemented by the Congress and other political actors. So I think that truly it will be okay. That in that sense will be okay. Thank you for the questions. And to some of them, we have to say that the constitutional text proposed a chapter.
A chapter on democracy that is democratic participation. And this is not present in the current constitution. And it's a chapter that points out many logic principles linked to democracy, and it shows mechanisms on democracy that identify as a participative and direct democracy. And I don't know if they might be considered direct democracy, but there is a chapter there. And not only in the logic of the question on defense of democracy, prohibiting certain movements, political parties, and regarding why the surveys give as a winner the reject option. There is a judgment, not only, not the text, but there is a judgment towards the process. It was a process that kept us watching and that had many issues and many, it was quite polemic, and they had difficulties to start working. We followed the discussion live, and that generated a need to reject the proposal of the text. What they most are rejecting is how they generate the dialogue and how they develop the process. And many of those that reject, they don't have a general vision, or they are not weighing everything, and they're simply focusing on 2 or 3 issues they don't like, and they reject the whole of the process. And there is a judgment, not of the constitutional text. Many people took the decision before reading it, and the decision was made by them as reject. So the invitation is to review the text, see it as a whole, identify if these demands, these promises are met in the text, and not focus on those issues that are specific and could be improved, and there are spaces and mechanisms to change. As Roberto is saying, this could have been done more, but others have decided upon the text, and some say, well, it is quite intensive, and there is a lack of trust, and that generates the reject option. On my side, regarding the question on being potentially authoritarian, a constitution will not generate a regime, an authoritarian regime, or a political crisis that we might think about. It's like giving more power to constitution more than it definitely has. Now, regarding the evolution of society and the challenges that we're facing, is that the text facilitating or making it difficult to access power? I see 2 things, and these 2 things, and I'm not saying that the sole consecration of these elements might generate an authoritarian regime. 2 elements that are risky: how the Congress of Representatives is defined, and this is with different limits that are different to the strengthening of after presidentialism, and now they add certain limits: bicameralism and elimination of certain rules that are long dated back to our history, and that is extracting from the space of Congress and towards a discipline, a fiscal discipline, and how they react to some practices and some rules that are established, and the role of constitutionality to law. There are modifications there. There is a constitutional court, a tribunal similar to the a constitutional tribunal today, but in terms of the perspective, there is no preventive control, and they reduce and limit the after control, the posterior control in terms of applicability. So it could only be applied by the judge. So there is a reduction of limits to the Congress and the judiciary power. This is not a problem in itself, but that was integrated without the majority of the judges, and that might generate factions. We're not used to that in our system. Now, regarding reject, the option of the reject, I talked about that. What were the reasons behind that? And I share what Roberto was saying, is that the sign has a structural problem because there are pockets of reject. And I do think that the process, as Miriam is saying, as well as the content, they have issues that are unavoidable, and that are not with such a firm positions, and that could have probably reduced the reject. People were always going to vote reject, others always were going to vote approve, but most of the Chileans are in between, they were not fully defined in terms of the vote. And from that perspective, there is an element that has to do with the process, with the content, and with an objective that the idea of seeing this new constitution, this new process as an opportunity, a projection towards the future, opportunities and fragmentation in society, and these things are not met from the process and also from the contents. Thank you, Alejandra. We don't have much time. I would like to ask a question to the group, and sorry for if we could take only 1 minute to answer. The Bolivarian process at the beginning of the 21st century, the processes in Venezuela, Bolivia, Ecuador, they had an impact in the region, in right-wing sectors. And when the process started in Chile, there was a fear of any constitutional reform because it was related to Chavism. And as David is saying, it's simply crazy. And what regional impact could the Chilean process have in the rest of Latin America? Could it be, or could it become a model, positive, negative model? And other countries, other democracies in the region? Let's start with Roberto.
Excuse me, Roberto, but we hear you well. Is it better? We can't hear you, Roberto. What I understand is that we can continue. David? What I will tell is not going to say as brilliant as what Roberto is saying. I think that we don't yet know, and it depends on a plebiscite. It is relevant, the comparison. If it is delayed, the process will have different signification. And I think it will be approved, and I hope it is. And if it is approved, the influence in two sense. The content of the text, as I said, it is a neo-constitutional constitution, different concepts with some new things, with a big influence that I think that will be relevant. But the process also, I think, has an influence. The constituent theory that has been produced in Latin America has been to some context dangerous. So I think that the model of the Chilean process is really a very, very good process. More controlled, and it will have some influence as well in the region, I think. Thank you, Miriam. Thank you. With a minute before going to the main question, I would like to clarify the Council of Justice has 17 members and 8 of them are judges. It's not that the majority is political, the majority is judges. Many say it will be political. And justice is the way to choose them, could be reviewed and perfect. But I want to clarify that. The other thing is that it is very difficult that we generate this negative concentration of power in the Chamber of Congress. I think that what we aim to is generate balance, and very difficult for the president with a majority in the Congress could place the authoritarian government program. First, because fragmentation is high in the political parties in Chile, and having a majority for an authoritarian government doesn't look like probable. And to show that the Chamber of Regions that is consistent with the regional state is an important counterweight to the decisions of the president and the Congress of the lower chamber, because in the second round of discussion, this Chamber of Regions gets several attributions that are very similar to what the Senate is now. The interesting thing is that the regions will have a voice in the decision making at a national level. And I think that is, if the Constitution is approved, that we are analyzing will have a very positive impact in Latin America, as we will see that it is possible to generate a new constitution that is born in democracy, and that we could be on an avant-garde position on a constitution that will establish a party democracy and an ecological state. I don't think it's just a social pact or political pact, but also intergenerational pact. Perfect. Let me add, Stephen, should I? And then Roberto closes. I think that this is a very good example as a process. David and Miriam said that when participating, it generates, it is not just the idea of one person. It is subject to rules, is limited, is constrained. It fulfills timelines and standards. From that perspective, I think it is a model that is really better compared to what we used to know in democracies. And I think it will become a case of a study because of details, things that could be improved, and many of them affected the final result. But I think that we should not put it aside. We had very little time and we finished with some results. So where I think it closed is understanding what a constitution is, what is the function that should be made in this political context. And Roberto was starting his presentation by saying that the Constitution of 1980 has the effect of twisting the field, a thing that I shared. The problem we see is that the proposition that is being given is also twisting the field. Then the expectations and the desire for the future is that we hopefully arrive in the best possible time, and the text is a new process. The reform for proposition of fixing, but we avoid twisting the fields, constitutionally speaking, to generate an impact and exclusion of different sectors, so we can continue making progress with a good political pact and social as a country. Alejandra, clarification. Twisting the field to whom? Well, I could say in each of the subjects, these are things that are part of the debate. For instance, what is the position of the state or the civil society? I understand we have differences, but the Constitution takes a stance or a position. Things that could be given to the political debate and majorities when we gain elections are imposed and they are fixed with the rigidity of the Constitution, just like the ecological approach, which is not just environment, and the other examples, not to take longer. Roberto, we are back with you. I should add some more question that I would love that you could take with a small reflection comparing the process with the Argentinian process of 1994. Well, it is part of the constitutions that in general appeared in Latin America with many rights and the old traditional structure in political aspects. I think it would have been a good opportunity to understand in the representation traditional systems, I mean, that are based on the existence of political parties with a central place that finished and it will never go under resistation. And that's part of the problem. Then I think that the unheard weight that within the convention the groups gained, the ones that are litigating internationally, and that they think that the social change is through gaining cases in the courts and the inter-American courts, totally a mistake that is against the democracy base that initially the convention had. So I think that is an error. That's it. I do not understand what Alejandra said and the point you asked. How is this twisting the field? I insist the rights that were created, if they were not existent, it was twisted field. If that was to be defined by the market, it was twisted field. But what we have now is that there's a base of common commitment, and the way they are implemented should be the result and only could be the result of an agreement. So in that sense, it's not a twisted field, but we will have the implementation of social rights, economic, environmental or not. Or in what sense, according to the agreement, whatever it is, if there's no agreement, the rights will not come out. So there's no way the field is twisted. I think it is a problem if we place it as such. And just to think about the learning or my teaching is not necessarily the teaching that I received, but what I learned is the idea of the plebiscite out is absurd. Many people will oppose or approve because of poor reasons and not for the result of how we understand the Constitution in general, but maybe because one strong agreement they will eventually reject. That's part of the problem. Please forget about that. Second, the contribution that many constitutions are doing is that in a society where you have a traditional underrepresentation of women, the parity character is important, and the reserved seats for Aboriginal groups with exceptional difficulties to gain representation is important for the future, I think. Third, I will strengthen what looks thin and weak, which is the conversation during the process. I think that constitutional conventions were developed or citizens' assemblies since it was done in Canada, Iceland, Ireland, with a development of learning that was mutual. All of them from previous experience. Chile failed in that. In the future, how can we strengthen the civil conversation during the process? I think also not to generate the fear that this convention eventually generated. The last point, when voting, we should not assess if in absolute terms this is the ideal constitution, no, but the comparison. Then with lack of democracy, legitimacy, and the problems that are assisted for the previous problem, this will open a future path that could have been a lot better, but it's a lot better than what you used to have. Okay, we're over the time. Unfortunately, I need to close. I have learned so much with you today. I would like to thank you, Alejandra Ovalle, Miriam Henríquez, David Landau, and Roberto Gargarella for the time assigned, and I wish you have a very good day. Thank you.